Hello, this is Matt on the Moon Lambo channel. I'm going to share with you some of the latest perspective from attorney Jeremy Hogan in this Moon Lambo hot jam. And you're going to love this because attorney Jeremy Hogan, he said that, quote, the chance of settlement in this case just went up tenfold. And, end quote. And it's interesting because most attorneys, from what I've seen, and attorney Hogan acknowledged as much, they seem to think that there's going to be some appeals going on in this case. Attorney Hogan doesn't think so, and he thinks actually because of the ruling from Judge Torres regarding the motions for summary judgment way in favor of Ripple and XRP holders, he thinks that not only will there not be appeals, but we're looking at a way greater likelihood of settlement. But it gets even better. But wait, there's more. He also stated that, in terms of the legal status of XRP, which of course it's absolutely not a security. If you can go to page 15 of Judge Torres' ruling, and she states that, and I'm paraphrasing at this point, but you can look it up. I've covered it a bazillion times already over the last week or so. She found that the token itself, XRP itself, does not satisfy the Howey requirements, meaning, of course, it's not a security. Now, attorney Hogan has said that he actually thinks that that's not something that can be appealed. Yeah, plenty to talk about here. But he means from a legal perspective, like it literally can't be appealed. But before going further, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice. And you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. All right, so here's a piece from the Crypto Basic titled Top U.S. Lawyer says, chances of a settlement in SEC v. Ripple case have spiked 10x. Following the court's ruling on the SEC v. Ripple case, legal experts have been speculating on the next outcome of the lawsuit. In what is considered a significant win for Ripple, the court ruled that XRP is not a security. It also added that the company's programmatic XRP sales on exchanges do not constitute an investment contract, and therefore, it is not a security. Meanwhile, many securities lawyers, including John Reed Stark and Mark Fagel, speculate that the SEC will appeal the part of the court's ruling it lost, and the Second Circuit will overturn the decision. And so look, I don't know what's going to happen. I know that most attorneys seem to think that there is going to be an appeal, but I just, as somebody who is not coming from the legal profession, just when I look at both arguments, the arguments for appeal or why they wouldn't appeal, I find attorney Hogan's argument for these parties not appealing to be the most compelling because the SEC has so much to lose if they appeal and it doesn't go well, because you're talking about binding precedent from an appellate court, and if it does go their way, what do they get? Because it seems like it wouldn't even change the legal status of XRP from non-security to security all of a sudden. That's not what would happen, actually. And you know what? I'll even just tell you now, as far as this idea of XRP, this idea of it being appeal-proof, it has to do with the fact that, in terms of what was put before the judge, what she was tasked to rule on, there are a number of things, but what she was not tasked to rule on specifically was whether or not XRP itself is a security by the nature of it existing. And so she did opine on that quite strongly. And it does have legal implications. So this is the law of the land, but it's what's known as dicta, D-I-C-T-A. It's a legal term. And so it's not something that she was tasked to rule on, but it's got staying power regardless, which is fascinating. And so attorney Hogan noted that because this is dicta rather than something that she actually ruled on, even if the SEC appealed, what do you appeal? You can't appeal just dicta. It's not something that was actually, that's not part of what the case was actually ultimately about, which makes this extra super rich to me because it's the SEC, in my opinion, that opened themselves up to this in the first place by overreaching, throwing out this bogus nonsense BS embodiment theory. They said that XRP embodies those efforts from Ripple and thus the Howey test is satisfied. Remember all that nonsense? Well, when the judge came out and said XRP doesn't embody, the Howey requirements, I don't think she otherwise necessarily would have gone out on a ledge to say such a thing, if not for the fact that the SEC put her in a position where she could and it made sense to. The SEC put themselves in this trap of their own making. And I think that's a beautiful thing. I'm just saying. Anyway, Peace continues. On the contrary, pro-XRP lawyer Jeremy Hogan believes Judge Torres' declaration of XRP as a non-security will trigger a settlement between the parties. In an interview yesterday with Darren Moore Jr., Attorney Hogan said the chances of the parties settling had skyrocketed 10x after the judge ruled that XRP is not a security. Attorney Hogan noted that the parties have not settled due to the SEC's demands. He speculated that one of the SEC's demands could involve Ripple registering all its future XRP transactions. Per Attorney Hogan, such a demand from the SEC would harm Ripple's business model. Yeah, and so let's pause to think through this. And it could. It certainly could. I do not have the answer, but let's think through this a little bit. First of all, I will state that David Schwartz, Ripple CTO, co-creator of XRP and the XRP Ledger, has publicly stated that he doesn't think that this is going to hinder Ripple's business model. I'm not privy to all of his reasons as to why he noted that at the time they were still kind of internally thinking through this to see what made sense. But I will note that it's not like on-demand liquidity itself, utilizing XRP as a bridge currency, is in and of itself impacted by this, other than the way in which XRP would be sourced on an institutional level. So if Ripple's on-demand liquidity customers acquire XRP from a firm that's, for instance, not Ripple, say it comes from just some random exchange, my understanding is that wouldn't be impacted. And then I also have a question, because Ripple also allows customers to lease XRP from them. Now, my guess would be that that's not technically a sale. Does it technically count as a sale just because there was some sort of type of purchase, quote unquote, perhaps, even though the ownership doesn't transfer because it's just a lease of the XRP and then has to be given back or paid back? I don't know exactly. I haven't seen the paperwork on that because, well, obviously it's quite confidential. So I can't say. I don't know what it's. And I'll tell you this, even if I did have that paperwork from Ripple and what they have their customers sign in order to get a lease of XRP, even if I had that, I would still need an attorney to tell me what the legal implications are. So I'm just saying there could be ways around this, and I think there are. So look, it could make it tougher for Ripple to operate their business model as is, but it doesn't mean that it's going to be some sort of massive hurdle. This could be something that they could easily get around, perhaps. And maybe leasing is going to be a part of that, which they're doing anyway. But it really could just be as simple as buy your XRP from somebody else and then loop it through here. Why not? Anyway, Peace continues, though. Furthermore, Hogan speculated that with Judge Torres' ruling that XRP is not a security, the chances of the parties reaching an agreement had soared 10x. And here's a quote from Hogan. Now that we have a non-security designation, that might change. The chances of a settlement in this case just went up tenfold from Thursday until now. We'll see what happens, as there could be a settlement in the works, end quote. And I hope that's the case. I would much prefer this than any sort of appeal action. And we'll know soon enough. But again, even if the SEC appeals, and I talked about this too, so I don't want to keep repeating myself, but if you're talking about them attempting to get an appeal now, it would be known as an interlocutory appeal. So then you're requesting that Judge Torres allow an expedited appeal, because normally you'd have to wait until the trial's actually over until you'd appeal. Unlikely that she would approve that prematurely. And so are we actually going to wait until that's all over and then there's still an appeal? I hope not. I would hope that sooner than later there's just some sort of settlement here, because the SEC lost. They just did. Even on the small part where they got to win on the institutional side, it's meaningless practically. I don't think it's going to harm Ripple's business model, and XRP holders sure as hell don't care. I'm just saying, they seem to be rather screwed. It does look like that. And so, another thing Hogan said too is this is the first loss that the SEC has taken in a crypto lawsuit that it's brought forth. And he said that, he doesn't think the SEC was expecting that. Oh, I think that's definitely true. He thinks the SEC was fully expecting to win this case. And I do think Hogan's correct on that point, which I also think speaks to the arrogance of the spawns of Satan that work at the SEC. And so, again, Hogan doesn't think there's going to be any appeals in the lawsuit, but, even with other attorneys disagreeing, I don't find their points quite as persuasive, just as a layperson. But, one thing that I think, especially in hindsight, is abundantly clear, and Attorney Hogan also pointed this out, it was a huge mistake for the SEC to go after Ripple. Huge strategic blunder. And, he said that, if it had been Gensler's decision to sue or not sue Ripple at that moment in time in late 2020, he thinks that Gensler probably wouldn't have brought the lawsuit against Ripple. At least not at that moment. Because, given that the SEC has shown that they have a coherent litigation strategy under Gensler, Hogan thinks that if Gensler had his choice, he would have just gone after the low-hanging fruit first. And by the way, let me also note that when I say coherent litigation strategy, that doesn't mean that it's a good one or a just one. It's an awful one and disgusting and repulsive. There's no moral compass involved with that. But it is a coherent strategy, which is basically, at this point, go after the exchanges. Go after the on and off ramps, because then you don't have to worry about all the bazillion projects out there, the tens of thousands of them. Because as Attorney Hogan noted, it's like playing whack-a-mole with all the projects that are out there. So rather than do that, you just go for the jugular effectively. And so, what's likely is that Gensler would have just and if anything, and if he were going to try and get legal precedence out of anything outside of the strategy that I just cited in terms of the on ramps and off ramps and going after exchanges. If anything, he would have tackled, rather than Ripple, he would have tackled much smaller projects to set legal precedent. But going up against Ripple, in their war chest of literally over $1 billion was not a smart move. Not a smart move. That's what Jay Clayton did, though. Not a smart move. Especially given that they're on the wrong side of the damn law. It's much harder to trick a judge into ruling in your favor if you have a ferocious competitor to contend with. And in this case, it was the SEC going against Ripple, but Ripple's attorneys, many of them, used to work at the SEC, and one of them used to be SEC chair. That was one of the attorneys that Ripple hired. So it's like SEC versus SEC. What do you think gonna happen, bitch, when you're on the wrong side of the law? I'm just saying. So this is beautiful stuff. But yeah, my favorite thing to come out of this is that Attorney Hogan says, I don't see how from a legal perspective you can appeal the part that matters, which is flatly that XRP itself is not a security, because it's not something that the judge was ruling on. It's a comment that she made. It's dicta. And so still it's law, but from his legal opinion, he doesn't see how you could actually, from a legal perspective, even appeal it from a technical perspective. Music to my ears, son. Music to my ears. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.